morning.
Good to see everybody again. As you saw, we scheduled the hearing. We're beginning March 28th. There was a delay in the back, and that was mostly having to do with the availability of our witnesses with regard to the meshing that with the various availabilities of the court. Obviously, both sides have hired expert witnesses or proposed expert witnesses, and they're from around the country, and obviously they have teaching and other schedules, so it's sometimes difficult to accommodate, but we managed, and we're starting March 28th. There was the reply to the motion to sever, which was filed as well. So that's been submitted, and the court will consider that motion, and we'll wait to hear what the court has to say with regard to the severance motion. Obviously, we thought that there were good grounds to join the case initially through the grand jury, and we think that that the case should be tried as one case for a whole host of reasons. So we'll see what the judge says about that. But that's basically it.
Sorry.
No, go ahead, you jumped the gun, but
I thought you said
early bird gets the worm.
Sorry, Mr. Attorney. Do you anticipate the Frye hearing will last over a course of weeks or months? Because he said April, part of the court will be closed.
Well, I think it's it's a hearing, and you're talking about bringing in these experts from around the country. So, and this is a very active court. The judge is on trial now, and I think if you look, the judge has hearings and trials scheduled, throughout the spring into the summer. So we are going to work around that schedule. We started now, but we have a number of witnesses. I would imagine the defense will have witnesses, and that's that. So it's gonna take time, but there'll be adjournments having to do more with scheduling than volume.
So how confident per day?
I'm sorry?
Pretty much one witness per scheduled day.
We'll see. I think for now, the anticipation on the first day is we will bring in one witness, and they'll cross-examine that witness. And what we want to do is we want to be able to get that witness back to.
And
send them back from whence they came.
And who is that first witness?
You'll find out.
DA, how confident are you that, and look at the cameras after I ask, how confident are you that the DNA evidence will actually stay and not be thrown away?
So if we were not confident, we would not have used it. Again, I don't want to get into it because we're going to have a hearing about it, right? So it doesn't really matter what I say. It doesn't matter what the defense says, but I think we're all intelligent people. I think we all live in the real world. We know that DNA technology is used in a whole host of medical sciences. It's far from unproven, quite the opposite actually. So this is an application of a very reliable and well-used science that we have to litigate, and that's what we'll do. But we feel confident in it. I'm sure the defense is going to say that they feel confident about it too. So that's why we have hearings.
DA, as far as the severing of the cases, did the judge indicate when he will make a decision? I apologize.
No, he did not, but I think the issue has been well briefed, so that should be happening relatively shortly, I would imagine.
So for those of us who don't know, the motion to sever doesn't require any kind of extra hearing. This is just going to be the judge weighs in on it and makes one decision, and that's that.
Ordinarily speaking, the judge could, the judge has the power to order a hearing on just about anything. But as I said, I feel that given the extensive information and the extensive grand jury, I think that this issue has been well briefed for the court, and I anticipate that decision being made on papers alone without requiring a hearing.
Can you say relatively quickly, I'm sorry, like a week, a few weeks?
Well, it's up to the judge and his court schedule. Again, I think it's well briefed, and so we anticipate a hearing on paper. Decision on paper without the necessity of a hearing. When exactly that happens, we really don't know.
DA, does the timing of this hearing affect in any way the ongoing investigation into remaining victims on Ocean Parkway?
Well, I think what we, I think there comes a time where we have to say that, a case has an investigation phase, a grand jury phase, a pretrial phase, and then, then a trial phase. We are certainly, with regard to this particular case, we've entered the pretrial and are heading towards the trial phase. So, that investigation phase with regard to this case is pretty much closed. That's not to say that we're not investigating other unsolved cases in Suffolk County, which we'll be doing all along.
Does that mean Huerman is not a suspect in any of the other murders on Ocean Parkway?
If that's what you took from what I said, what I've said all along is when we have a unsolved murder, we don't assume a particular person is or is not a suspect. We start at that murder, and then we move out from that case and the crime scene and the evidence we find. So until we're able to charge, until we're at the point where we think we could go into the grand jury, we're not going to say we think someone did it or we didn't. Someone didn't do it. It doesn't matter what we think. It matters what we can prove. So we'll continue to look at those other murders, but we're not going to ascribe them to one person or the other until we can prove it. And we're not at the point of charging anyone out for any of those murders.
Last time we were here, you were uploading all that information onto a disk. Have you handed over all the information?
So there was a 14-point letter that was provided by the defense to us, and all of that information, to the extent it exists, we provided to the defense on a hard drive.
But is that finished now?
It's finished.
In the Frye hearing, is there a burden on one side or the other, and in terms of establishing, this is viable evidence? And can you just, in layman's terms, explain what you might have to convince the judge of?
Sure. So in a criminal trial, the burden is always on the prosecution. So, except in the instance of an affirmative defense, and that's a whole different story. But generally speaking, the burden is always with the prosecution. Always remains with the prosecution. So the burden is on us. And in layman's terms, is with Frye hearing, is we have to establish that the science that we're seeking to use is generally accepted in the relevant scientific community. It was properly done and therefore can be relied upon by the jury in making a determination in the case.
Is there a jury in a Frye hearing?
No, I'm just saying, but what the judge is a pretrial, just like if it was, the judge has to make a determination with regard to the relevance and the propriety of evidence. Once the judge makes that determination and we're allowed to show it to the jury. Obviously, if the judge disagrees with our position, this evidence would not be allowed to be shown to the jury.
How soon after the Frye hearing might we get a trial date?
I have no idea.
And those frozen assets you talked about in the past, money that you were trying to get, can you give us an update on that?
Sure. Unbelievably, seemingly out of nowhere, the investigation is over, and we're going to be getting access to that money.
How much money is that?
I would say, last time I checked, I would say it's about $13 million.
And how will you use it?
Well, so we could use it for a variety of ways. We could use it to buy equipment. We could use it to pay overtime for our employees, in their investigative work. So those are certainly two areas which we're going to utilize that money.
It sounds like you were surprised that you got it suddenly?
No, I'm not actually. I think it's amazing when the government is responsive. What can happen?
And sir, one more time on the importance of not severing the case, just even in terms of taxpayer dollars.
Well, I mean, I think if you look at it, from a judicial resources and law enforcement resources standpoint, obviously, doing this once instead of 7 times, it's going to be 7 times more expensive if you had to do it multiple times. But when you look at the evidence in this case, the theory of the people's case, that planning document, the methodology, the modes that were used, the theory of the prosecution case is, and again, these are just allegations, but our allegations are, this is an individual who had the specific intent to kill, to identify, locate, lure, obtain control over, and murder multiple victims. So that's the theory of our case, that's what our evidence shows. And so evidence of one murder would necessarily be evidence of the other alleged murder. So even if you were to separate it, most of the evidence would be identically the same in all 7 cases.
Not to, that's the first time I heard anybody say 7 cases. The defense didn't ask for breaking it up into 7 separate cases, did they? They asked for like 5?
I think it was 5.
Okay, good.
So that was a bit of a exaggeration on my part. So it's 5. It would be 5 times as expensive.
Does the judge offer rulings after each Frye hearing before the next one starts, or is it all the way?
No, so it would be, we have to, that criteria that I mentioned before, we have to establish that criteria, and we establish that through a series of witnesses. But just like any kind of evidence, say a photograph, sometimes in order to get a photograph or a piece of evidence in, you can't do it through just one witness, you do it through multiple witnesses, and the trier of fact, whether it's the judge or the jury, will wait until all of that evidence is in before they make a determination. In this case, we'll have the opportunity to present that through a number of witnesses, and then the defense will obviously cross-examine, but then they have the opportunity to call their witnesses, which they may do. So it's not until all of that evidence and the hearing is closed and whatever argument the court allows, well, once all of that is done, then the court will render a decision.
How many witnesses are we talking about?
I can't speak to the defense. I would think that we're talking probably for the prosecution at least 4 witnesses.
Any update on identification of the Asian doe victim and the peaches or any other?
I don't believe that those individuals have been publicly identified as of yet.
But do you have the identities?
That is my statement. Anything else?
Thank you.
Okay.